Welcome to the Supreme Court of the United Kingdom, where today we are having the fourth day of the hearing of the appeal in the case of test claimants in the franked investment income group litigation and HMRC, a case concerned with a multiplicity of issues concerning the taxation of multinational companies and the requirements of EU law. We are currently hearing submissions on behalf of the Revenue presented by David Ewart, Queen's Counsel. Before you resume your submissions, Mr. Ewart, we've been considering if there were any matters on which we particularly wanted further assistance from Counsel in the course of today. And there are, I think, two broad areas that I can mention to you. Firstly, in relation to sections 85 and 86 of the 2019 Act, we would be grateful for any assistance you can give us, as or you and Counsel, obviously, from the test claimant, as to the rationale of, in particular, the dates that appear in section 85, and the 6-year period that's specified in section 85. The second matter relates particularly to issue 15, although it may also have a bearing on issue 17. You've presented to us an argument that the obligation to give tax credit either in relation to issue 15 or, for that matter, in relation to issue 17, ought to be taken into account in calculating the extent to which the revenue was enriched. Another possible analysis would be to accept that the revenue was enriched by the ACT paid, but to regard the obligation to give tax credits as a change of position, giving rise to a defense pro tanto. And we wonder whether, first of all, that analysis is open, and secondly, whether that analysis stands up, if it is open to us. The other issue that we would wish to raise also relates to issues 15 and 17. The taxpayer's argument in relation to issue 17, if I can take the risk of boiling it down to a sentence or two, I think what it boils down to is that EU law requires a tax credit to be given in respect of the foreign tax paid with the consequence that the giving of the tax credit can't be used to diminish the amount which has to be repaid by the revenue in consequence of its receipt of the unlawful ACT. And the point which we would welcome further assistance on is, if that is a good argument in relation to issue 17, is there a reason why it's not an equally good argument in relation to issue 15, where we're concerned not with tax credits of the kind that issue 17 is concerned with, but with in particular the tax credits required under a double taxation treaty. So I hope those three issues, my colleagues will intervene if I haven't correctly and fully identified the three issues on which we would welcome further assistance from both parties during the course of the day.
Thank you. Good morning, my lord. I will deal with the question about the dates when I come to dealing with section 85,
yep,
which will probably be this afternoon, depending on how things go. As regards your 2 points on issue 15, can I deal with the last one first?
Yeah.
Because it may be the easiest. The answer to that is the reason that I was showing you Mr. Justice Henderson's judgment in the Pirelli case yesterday. And it derives from the reference which my learned friend Mr. Aronson referred to, and we referred to, in a different GLO called ACT Class 4. And ACT Class 4 was about payments of dividends by UK companies to foreign parents and the obtaining of tax credits under double tax treaties. And it was arguments about whether, for instance, if there was no suitable treaty between the UK and the particular state, was there an EU requirement that they had to give a tax credit because they gave a tax credit to other foreign companies in other member states which did have a treaty? And the answer to that was no. And there are other questions about whether there was a requirement for the UK to provide tax credits, and the answer to that was also no. The general principle being it was for the state of residence of the dividend receiving company to deal with any double tax problems. So it wasn't for the UK. Unless and to the extent that it actually taxed the dividend, which was paid to the non-resident, it didn't have any obligation to give tax credits to relieve double taxation.
Right.
So that's what.
So if I can just explore that with you for a moment, Mr. Ewart. So the section 231 credits are required by EU law. We're no doubt about that. But one might have thought, in principle, it could be argued that that the UK's failure to give double taxation credits in respect of income on which tax ultimately had been paid overseas in another EU member state might have an impact on freedom of establishment if double taxation credits were being given where the tax had been paid further downstream, further down the tree, if you like, in the UK. But you say that argument, we don't need to worry about that because it's effectively been because the EU position has been made clear in ACT Class 4.
That's right. Yes,
Right.
I could later take you back to it, but it's all contained in the judgment of Mr. Justice Henderson. In the,
Fine.
I think the case is called the ACT Class 4 and 2 and 4. Yeah.
Thank you very much.
So, as regards the other question about change of position, I will come back to that perhaps again after lunch, if I may. But my initial reactions are: you will be aware that the revenue ran arguments on change of position.
Yes.
In these proceedings in the second stage, and it was held. Sorry.
But I thought, Mr. Ewart, that that concerned general public expenditure. The argument, correct me if I'm wrong, but I thought the argument was that the revenue had changed its position because the tax receipts had been spent on hospitals, defence, and so on and so forth.
Yes, that's right.
Now,
yeah,
well, there might be a different argument in relation to tax credits for the reasons discussed, for example, by the House of Lords in Pirelli. The closeness of the connection between the receipt of the ACT and the giving of the tax credit.
Yes. The other problem, of course, is that below the taxpayers ran the argument, which equivalent to issue 18 in relation to change of position, which was also accepted by the courts below. They said you couldn't have a change of position defence where you were recovering unlawfully levied tax, and that's because of Lady and Kid, etc. So we'd have to get over that problem as well, and that was decided by Mr. Justice Henderson and the Court of Appeal.
Right, and they took that view, did they, in relation not only to the Woolwich claim but also the MG claim?
Yes, all claims. Because they said that even when it was a mistake claim, what you were doing was using the mistake claim to recover tax that had been levied in contravention of EU law. Which I think, my lord, is also the reason in the Supreme Court the first time round why mistake claims were covered by the principle of effectiveness, because they were being utilised indirectly, you might say, to recover unlawfully levied tax.
Yes, I see. Thank you.
So, yeah. Can I myself, before I deal with issue 17, go back to a question raised by Lord Sales yesterday. His question was, well, could the revenue recover the tax credits from the Ford parent in unjust enrichment? And having reflected on this overnight, I think the answer is no. And the reason for that is it would require the revenue to be relying on the Ford UK companies, subsidiary companies, EU law right of establishment, which is something that the government can't do. The government themselves cannot rely on EU law, the direct effect of EU law, against a citizen or a company. So if the revenue had gone to the Ford US shareholders and said, well, we don't have to pay you these tax credits because of EU law, the answer would have been, well, it's not, the revenue can't say that. On the other hand, when an individual or a citizen is seeking to enforce their EU law rights, then you can take account of that, and that was the point made in ITC. I'm sorry, Lord Sales.
But I thought that one starts from the position that the relevant ACT is unlawful ACT, so a nullity which ought not to have been paid. It's true that one gets to that position because of the EU law rights of the relevant companies, but one arrived at the position that that was simply money that was not due to the revenue. But when the revenue then turns to consider whether it has to pay anything to Ford, I'd understood the effect of your argument based on Pirelli was that if it's appreciated that no ACT had been paid, had been due, and therefore ought not to have been paid, there was no liability that arose under the double tax treaty on its proper interpretation. And I don't see at the moment how that involves the state relying on EU law rights of individuals. It's just working through the nullity effect of the ACT, isn't it?
I think it's slightly more subtle than that, my lord. The position would have been if the taxpayers, the Ford company, had enforced their EU law rights and so had said we're not required to pay ACT, then I think that may well have been the position. But my point was that the revenue wouldn't be able to simply say, well, we know that Ford UK have EU law rights. They could say that these dividends are not allowed to ACT, and therefore we will sue the shareholder or we will refuse to pay the tax credit to the shareholder.
But I mean, the ACT was either due or it wasn't due. We know it wasn't due, and therefore this is my understanding of your argument. And so please correct me if I'm wrong. Therefore, on your approach to the interpretation of the double taxation treaty, there was no liability to pay Ford US under that treaty. Have I misunderstood?
Well, yeah, I think the European law position is more subtle because I think that taxpayers, or individuals in the UK, would be entitled to rely on domestic law. They wouldn't be required to enforce EU law rights. And the same applies. I was going to make the analogy with with VAT. An individual is entitled to rely on the UK domestic VAT law. Now, it may be in some circumstances there are provisions in the directive which have direct effect, and an example of that was in the ITC case. There was a case called Claverhouse which decided that as a matter of direct effect of the directive, these particular supplies were exempt. But the taxpayer would have been entitled, if he'd wished to simply carry on treating them as standard rated, because that's what the UK domestic law said. And it was only because they enforced their EU law rights. And we can see this, it's part of the discussion in ITC. I don't know whether I want to take you, I'll take you to that. The reason why you had to take account of the input tax credits was because the taxpayers had enforced their EU law rights and were claiming on the basis that the supplies were exempt. But if the revenue had simply, after Claverhouse, if the revenue had simply gone to the managers in ITC and said, look, Claverhouse says this should be exempt, we want the input tax back, I think the response would have been, well, we're entitled to rely on our domestic law right to recover input tax. We're not claiming any EU law rights. The revenue can't enforce it against us. We're entitled to our input tax. So,
Mr. York, the difference there was that the VAT directives are directives, and insofar as they've not been implemented by the UK, the taxpayer can still rely on the directive if it confers a directly effective right. He doesn't have to, but he can. But the government can't rely on a directive which it has failed to implement.
yeah.
But in the present situation, we're not concerned with a directive, we're concerned with treaty obligations,
Yes.
which are law in the UK without implementation by virtue of the European Community Act. And they're higher law than statutes.
Well, with respect, the directives are law for the same reason in the UK.
But there's an EU principle that you can't. Effectively, governments are stopped from relying on their own failure to implement a directive, but they're not. But but they can't rely on an unimplemented directive as against an individual. I think in EU law, the explanation is mainly based on legal certainty.
Well, I think it's more to do with, they talk about horizontal and vertical effect. But I would submit the same principle would apply to the treaty provisions, which are directly effective in the same way. The government couldn't rely on a right of establishment against a citizen for obvious reasons. It doesn't have a right of establishment. I mean, these rights vest in the citizens.
That's a different issue, that the nature of the right may be one which is not capable of enforcement by a government.
Yes. Well, that was my point. But the government, in order to recover the tax credits, the government would have to be enforcing an EU law right. It would have to be because the only way you get to that is because there's a breach of freedom of establishment.
No,
yeah.
Well, I really am struggling to follow this argument. I mean, the taxpayer is himself asserting that the ACT levied is not due and is therefore a nullity. On your interpretation of the double taxation treaty, a precondition for the right of the US parent to receive the credit is that ACT was levied, as I understand your argument.
Yes.
That precondition doesn't apply. It's not satisfied in the circumstances that we're dealing with. And I can't see it matters that it's not satisfied because the UK companies have asserted, or foreign companies have asserted EU rights in the UK, or
but that's now, my lord. For the revenue to succeed, as I understood you were suggesting an action in unjust enrichment. They would have to show that the original transfer was defective. That is, that they made the original transfer under a mistake, let's say, or something like that. And it's difficult to see how that can be the case, because when the original transfer was made, it was perfectly due. And it's not a case of retrospective effect.
But forgive me, Mr. How could it have been perfectly due when, following the analysis of the Supreme Court in Prudential, the ACT was a nullity? It wasn't due.
So I think we're going around in circles. That's because the taxpayer is enforcing their EU law rights. And I agree, once they enforce their EU law rights, then you can get... Yeah.
So be it. The taxpayer is enforcing their EU rights, the effect of that being that the ACT was a nullity. And therefore the precondition for payment of the tax credit to Ford US
you would have to say that effectively had a retrospective effect, that applied from the date the tax credits were actually provided. And so there was a mistake at the time the tax credits were paid. But that is a very artificial situation, because the revenue couldn't have resisted the payment of the tax credits at the time. There's nothing they couldn't have said. If they had said, we're not paying you the tax credits, the answer would have been, well, you've got to. I can't see any ground on which they could have resisted it at the time they paid the tax credits.
All right, thank you.
That's my point. So,
thank you very much.
Yeah, to be able to claim them back now, you have to show that it was deemed that they made a mistake, I suppose. 20 years ago, when they paid the tax credit.
But isn't that equally true at the UK parent level? I mean, the UK parent level proceeds with its mistake-based claim for restitution of ACT that shouldn't have been paid, on the basis that the obligation to pay it was a nullity, and it paid it by mistake.
Yes, but
are we into some world of relative nullity, so that it's only a nullity because the UK parent is entitled to EU rights, although it's not a nullity for the purposes of deciding what the obligations of a US shareholder are?
Well, at the time of the payment of the ACT, assuming the law to be what it's been found to be now, the taxpayer payment of the payer could have resisted payment of ACT because they had EU law rights which they could have enforced. And so they did make a mistake in that sense. But the revenue, when it paid the tax credits, that's the difference. They couldn't have said to the to the parent, we don't have to pay you.
But surely the mistake,
position.
but the mistake isn't a failure to exercise EU rights. The mistake is a failure to appreciate that the apparent liability to pay is a complete nullity.
But it's only a nullity in the hands of that taxpayer because they have EU rights. Other taxpayers who paid ACT wouldn't be able to say it was a nullity because they may not have EU rights. I mean, for instance, if they paid, if the dividends came from the US, then the original dividends came from the US and they paid on that because it's a third country, then the payment of ACT would be perfectly lawful. So it crucially depends on the taxpayer or the claimant having an EU law right. It's not that because of this, ACT becomes a nullity generally for every purpose, for everybody. It's a very restricted, it's restricted to the particular claimant who can exercise rights. I think that's fundamental to the EU law. And there's been cases about this because taxpayers have claimed that because some provision has been held to be unlawful on EU law grounds, that they can take advantage of it, even though they don't have any obvious EU law rights. And it's been made clear that that's not the position. It's not void for all purposes. So the legal analysis that the taxpayers could have enforced at the time is not one that the government could have enforced. I think this is very fundamental, the EU law. The government couldn't themselves just go and say, there is this EU law analysis and therefore you've got to pay us credits back or something like that. Lord Sales.
Well, I mean, I slightly question that. I mean, suppose the penny had dropped before the government paid the credit to Ford US. That there was this fantastic EU argument that taxpayers had that the ACT was unlawful.
Yeah.
But they weren't making them. They weren't making the argument that you're assuming.
No, but the UK then realises that to comply with its treaty obligations, it ought not to be charging ACT, no matter what its legislation says.
Well,
what happens then? It knows that there isn't a right to charge ACT.
But wouldn't the practical answer be that it would simply legislate to stop charging ACT? I mean, it wouldn't do it voluntarily, or it wouldn't do it without if it realised the position, truly did realise the position, then it would take steps to change the legislation, surely, at the time. But I'm not sure it would be in a very strong position if it didn't do that.
All right, thank you.
Can I then move on to issue 17? And it's this important question about whether the tax credits are the tax credits paid to the shareholders. I have to be clear about this, what we're talking about. We're talking about the shareholder tax credits in my diagram, rather than the FII credits given to the UK company. Were they required, or are they required by EU law? And the starting point for this is what Mr. Justice Henderson held at first instance, at the first time round. And you'll find that it's EF 1049, which is in core volume 2. Paragraph 150. This is just his conclusion I've taken you to. There were a couple of methods suggested by Mr. Ernson as to how the matter should be dealt with. And he says either of those methods would achieve the objective of ensuring foreign dividends from member states are treated in the same way as domestic dividends for ACT purposes. And like Mr. Ernson, I slightly prefer the first method. It seems to me more in accord with the structure and philosophy of the UK partial imputation system, confer a tax credit on the relevant foreign dividends and then treat them as FII in the hands of the recipient, rather than exclude them from the scope of charge to ACT. So what he decided was that the foreign dividends received from relevant companies would be treated exactly as FII under the UK system. Now, I quite agree, if that was the result of the litigation, then the argument would be that you simply follow through all the consequences of them that being FII, and one of them, no doubt, would be that a tax credit would be available. But that conclusion was reversed by the Court of Appeal, and I think my learned friend showed you the passages. If we could just take you to EF 768. And in paragraph 105, they say all the court is entitled and bound to do is to see whether section 231 can be read so that the right to a credit which is conferred extends only in the circumstances expressly mentioned in 231, but also takes into account the rights of persons under community law. And then in 107, it therefore falls to this court to determine the appropriate confirming interpretation. In our judgment, a conforming interpretation can be achieved simply by reading in words that make it clear that resident companies can claim a credit under 231 in respect not only of qualifying distributions made by resident companies, but also distributions made by other companies, to the extent that community law requires a tax credit to be given in respect of that income too. The extent of that entitlement can be investigated when the section falls to be applied. So what they were saying was, well, it's a conforming interpretation of section 231, but it's to provide a credit which is required by community law. And they say, well, you have to determine that when you come to investigate the situation. And that's what happened in the second stage, as you know. In relation to ACT, I think I showed you what Mr. Justice Henderson said about the CT61 method. And the purpose of the tax credit, the EU tax credit that was being generated, was to nullify the charge to ACT. The basic position, if you stand back, is some amounts of ACT had been unlawfully charged because it was a breach of the freedom of establishment to charge ACT in those circumstances, in circumstances where they had received foreign dividends, EU dividends. The question then was, how do you determine, as I think I explained previously, how do you determine how much of that ACT has been unlawfully charged in the past? And the way to do that was the method of sort of computation, if you like, of doing that was to create notionally an EU tax credit when the income was received from the EU at the bottom company, and then trace that up through the group. If you remember, I showed you that the diagram, which is diagram 8, which is one example of a UK group, and you would trace it using the various rules in the UK legislation, modified to some extent, as explained by Mr. Justice Henderson, to take account of the fact that it's not an actual UK credit, so it doesn't quite work. It has to be slightly moulded. And so the purpose of this was to nullify the ACT charge at the top company level. That's what it did, and it achieved that. So once you had an amount of credit at the top company level, you took that into account in reducing the amount of ACT that would be notionally that was charged. Remember, all this ACT was charged years ago, so we're doing all this obviously in retrospect. You reduce the amount, and you then work out how much was charged unlawfully, and at what point, at what time, because the time in which these things happen can be important because of interest charges and limitation periods and other things. So that was the purpose of that tax credit. But what it didn't give in my submission was FII. it didn't create, because that's what Mr. Justice Henderson said, and that's what the Court of Appeal reversed. So we say there's nothing in that which requires a shareholder tax credit. The true analysis has to be, we would submit, is not giving a tax credit a breach of a treaty freedom? If that's the case, then it would be required. I quite agree with that.
Mr. I wonder if I could come in at this point.
Yeah.
You refer to the Court of Appeal paragraph 105 and 107. Can you explain what it was in their reasoning that caused them to disagree with Mr. Justice Henderson?
Well, I think they thought it was going too far to treat it as FII, because
Why?
Well, there were a number of reasons. What one would be, primarily, I think, you've got to go back to the way people were thinking about it at that stage, because you've got to remember, looking at Mr. Ames's helpful chronology, we are here in between the first reference and the second reference, and at that time, on the basis of what was said in the first reference, it was thought that what you had to give credit for was foreign tax paid in relation to the dividend, because that's what the European Court seemed to have said. So that was everyone's understanding at that time. It's not our understanding now, because we've had the second reference and the FNRs, etc. But at the time, it was thought that it was foreign tax paid. And one of the points that was being made was, well, if you treat it as FII, then that's essentially giving them a credit, could be giving them a credit at a much higher rate than the amount of foreign tax paid. So that was one of the problems. I mean, that there were a number of points that were made.
Yes, but now we know that's wrong. Why, in principle, is Mr. Justice Henderson wrong to say that the giving of a tax credit at the UK Water Edge company should not give rise to FII? Because as I understand the consequence of your reasoning, the net effect is, while the UK Water Edge company pays less ACT, the consequence right the way up the hierarchy, assuming several layers of companies, is that there is reduced FII all the way up.
Actually, no. What normally would happen, my lord, would be the opposite. That the ACT would be paid at the very top company. And so all the way up, what actually happened in the past, factually, is that dividends were paid under group income elections.
Yes, I know, but take group income elections out of it at this stage.
Okay, but that's the system that was what the factual situation we had to deal with. Of course, that was why there was a problem. Because if the ACT was in fact paid at the bottom, we wouldn't have had this difficulty, because we would have known when the unlawful tax was paid. It would have been easy. The whole exercise would have been simple. The problem arose because the ACT wasn't paid at the bottom when they received the foreign dividends. It would, as I say, it would have been very simple to have done the exercise. You wouldn't have needed these EU tax credits. You could simply have looked at what happened. You would have seen the EU income coming in. You'd have seen the distribution out and the ACT being paid, and you'd be able to match them, probably reasonably simply. But the problem was that didn't happen. And so dividends were received from the EU at the bottom, and they might not be redistributed at the top for a number of years, because they'd be paid through various companies. At some stages, the companies didn't pay on dividends, they retained the money, or they passed it on, loaned it to some other company in the group, and then they may have paid dividends in subsequent years. So that was the problem, my lord. So taking out the group income elections really changes the whole thing.
Yes. So
I'm sorry, but you were wanting to ask something about.
No, I just wanted to work out. I mean, you're saying that in reality you were dealing was it almost exclusively with group income elections?
What usually happens, I think I said, there would be some cases in which ACT was paid at a lower level for various reasons. Sometimes if they had profits that they could set the ACT against immediately. But over the bulk of cases, the ACT was paid at the top company.
Well,
I don't know whether that affects your question, but I'm just wanting to...
No, but I'm just trying to work out, as a matter of principle, where this takes you. If ACT is paid at a lower level, let us say at the UK Water Edge Company, does its payment of does the FNR credit, which it's given there, would that not, as a matter of principle, give rise to FII?
No, what it would do is reduce the amount of ACT. Well, it would tell you how much of the ACT it paid was in the past was unlawfully paid.
Yes.
The same point of principle arises when you use the FNR as if you use the actual tax, because you still have to compare the FNR to the UK rate. So if the FNR happened to be lower than the UK rate, you still would get less than treating it as FII. The position in principle is the same.
Yes.
Now, in practice, I'm sure most of the time, the FNR of foreign states, particularly European countries, was probably above the UK ACT rate in most cases.
Mm-hmm. I
think there are a few examples of dividends where it's not, but I mean, basically it would be in practice. But the point of principle is the same, that treating it as FII would always, well, it would have a number of knock-on effects in other parts of the legislation as well. That's another one of the problems. Once you treat it as FII, you then would look at other provisions which would say what you can do with FII. But anyway, it would also, but you still have the point of principle that you by giving them FII, you are treating them as having the credit as being whatever the FII rate would be, whereas it might not be. It's still necessary to go through the process of looking at what the FNR actually was in relation to the dividends that were received. And of course, there's more of a problem when you come to look at foreign third country dividends, which would in some circumstances have lower rates of tax. But anyway, that's the principle. So I think the difference is, do you treat it as FII with all the consequences in the UK legislation of FII? Or do you simply treat it as a tax credit, which nullifies the ACT charge, which is what you're trying to do? And none of this litigation here was about shareholders' tax credits, or sorry, the right to shareholders' tax credits. I mean, that has arisen, as I think the learned friend showed you, in the parallel GLO, where the shareholders are suing to recover the tax credits. But all of this litigation is about the group companies. So none of it was focused on, does this give the shareholders a right to a tax credit? That wasn't the aim of what we're talking about.
No.
The aim was to compute the unlawfully charged ACT, which is...
Yes, I've no doubt the aim is to compute the unlawfully charged ACT, but if
and the unlawful corporation tax, obviously.
If one had been operating the system correctly from the start, isn't the logic of freedom of establishment that all the companies right the way up the corporate hierarchy would get the benefit of FII in respect of the foreign the tax paid on the overseas dividends, in order to create equivalence between the domestic hierarchy and a corporate hierarchy involving EU subsidiaries?
They would, if we'd appreciated this at the beginning,
Yes.
I don't know whether they possibly wouldn't have enacted ACT in the first place, but if they did, they would have had to provide us. Well, all they would have been required to do is provide a system in the way that we have actually been artificially, notionally operating it in this litigation, which is a credit for the FNR of the foreign company, paying the company which generated the profits, the foreign company, paid tax at a particular nominal rate, and it's that rate that you would be entitled to a credit at, because that's what the European Code have said. That's what's required. You could have gone further, of course. You're perfectly entitled. Member states are always entitled, and they might have felt it was simpler to have a much simpler system, which did give it as FII. I can imagine that could be a response, a policy response, because they might say, well, it's much easier. But we're not really talking about what's the most. We're not talking here in this litigation about what's the most convenient administrative system. But
no, I know not. But
what's required.
You are saying that all that European law requires is that the FNR is given, even in the case of a water edge UK company paying ACT on its distributions. All that you say, all that is required is that you deduct from the ACT an FNR credit at that level, and nothing else happens up the hierarchy. That's your position.
Yes, because nothing else needs to happen, because nothing else needs to happen in this litigation, because in fact the companies did pay in the real world.
Yes.
Which did actually happen. They would have paid with FIR. There would have been real FIR paid up.
Yeah. Yeah. Okay. Well, I have your position.
So it doesn't create more. I think what I'm saying is it doesn't create more FII. It doesn't need to. There's no need to create any more.
Could I put this in a slightly different way? This is all about whether to treat wrongly paid ACT as unjustly enriching the revenue, broadly common ground, and whether to treat shareholder tax credits as impoverishing the revenue. That's the whole basis upon which issue 17 is being analysed, as I understand it.
Yeah.
And if that's right, in order to see whether there's an enrichment or an impoverishment, do you not have to construct a counterfactual as to what would have happened if the process had been completely EU compliant when it originally happened? And you say, well, we would have been, we were enriched because the ACT shouldn't have been paid. But you're not suggesting, as I see it, that a completely compliant EU compliant structure would have led to the shareholders not getting their tax credit. In other words, the counterfactual still involves the shareholders getting their tax credits. And if that's right, why is it an impoverishment?
Well, it has to be my argument, my lord, that it would be a compliant system. Whether it would be a sensible system is another matter, but it would be a compliant system where there's no ACT being paid for the tax shareholders not to get a tax credit. That is exactly our case.
So you have to say that it would be compliant with EU law for shareholders not to get a tax credit in relation to foreign dividend income, although they would get a tax credit in relation to UK dividend income. So that differential of treatment between the two would still exist, now no longer at the parent company level, but at the shareholder level.
Yes, but the difference would be that in the UK dividends, there would be a payment of ACT somewhere in the chain, and that's crucial to the tax credits. That this is our point. Whereas in the hypothetical system that you got for the EU dividends, they would simply suffer no ACT ever in the UK. They would simply be paid up free of ACT from the UK Water's Edge company and out to the shareholders. And that's what I mean, I agree, this is the heart of the matter. We say that is fundamental to the system. And therefore, it's not comparable to say, you can't compare a situation where there's a UK dividend where ACT is paid in relation to the tax credits, and one where it's not paid.
But I think I think you have to say that on my analysis, it would have been a perfectly EU compliant counterfactual for the revenue to have said, okay, we won't charge ACT anywhere up the corporate structure to the extent that it's franked by FNR. I'm putting it in a loose way.
Yeah.
But we'll still hit the shareholders.
Well, the shareholders won't get their credits, which are linked concomitant of the ACT being paid. Yeah, exactly. Okay. Yeah, that's precisely it. Yeah.
Thank you.
Yeah, Lord Sales.
Well, doesn't that way of putting it take you back to Mr. Aronson's complaint that this is another way of the UK government trying to run the argument that the ACT system is completely predicated on payment of ACT within the UK system, and there is no comparable, no comparison to be drawn with the wider EU context. And we've seen that argument presented in various guises in various of the EU cases. And as I understand it, rejected each time because the EU analysis is to take a wider view and say that what this system is aimed at dealing with is ameliorating the problem of double taxation of company profits, which come in at the, if you like, at the bottom of the tree, and then leave at the top of the tree and go to the ultimate shareholders. And if one looks at the system in that way, doesn't it become very difficult to justify the position that you now seem to be arguing for, that it would be legitimate to, in effect, tax the shareholders in relation to foreign dividends because they don't get a credit, whereas they would not be taxed in relation to UK dividends because they do get a credit. That just seems to perpetuate the basic problem with the ACT scheme as it was devised.
Well, it is a different problem from the one which had been dealt with previously, because the problem dealt with previously was that the dividends were being taxed twice, both to corporation tax, but also to ACT. So they're being taxed to foreign tax, and they were being subject both to corporation tax, but even if there wasn't any corporation tax, they're being subject to ACT. Then that was a double taxation that was problematic. It's quite a different issue as regards the shareholders and their taxation in the UK. It's up to the UK how they tax the shareholders, I submit. So it's not a question of economic double taxation of the.
But they couldn't compatibly with EU law have a system of deal for shareholders in a way which incentivized shareholders to invest in companies whose subsidiaries are entirely UK resident, rather than in companies whose subsidiaries may be based in other EU member states.
Well, depends whether you say it does incentivize them, because the UK companies are subject to disadvantages as well, because they're within the ACT system. So it's not as straightforward as to say, well, that will disincentivize them, because they're not looking at two things that are the same. I agree. If they were absolutely the same, yeah. So I do think that is that is the heart of the issue 17. So which is what I was dealing with. So I'm not sure that I have anything else more to say about issue 17. No. On issue 18, I just had a couple of things to say. We would agree with what Lord Sales said, that if there is an effective remedy under domestic law to recover tax levied contrary to EU law, then EU law doesn't demand any other remedies. And in fact, Lord Sumption made this point in the first Supreme Court decision at paragraph 199, which is EF 1224. We want to look at that, but I think it's a fairly obvious point. Of course, that's not to say that if there is another remedy, you can't use it. Of course, you can. It's, yeah, EF 1224, para 199. He also makes a point which is possibly quite relevant when we come to look at section 85, where he says, if Parliament had retrospectively created a concurrent right to recover tax on the ground of mistake, but in the same enactment made it subject to a limitation period of 6 years to run from the time of payment, not disputed that the state of affairs would also satisfy the requirements of EU law. If that's right, it's difficult to see why providing a statutory remedy like section 85 with a limitation period would breach EU law. But I'll come back to that when we deal with that issue. And as Lord Reid rightly said, the first Supreme Court decision and the third reference are all about a situation in which there were two remedies under national law, and one of them was, at least to some extent, taken away from a taxpayer. So they had a right to recover in mistake on day one. Legislation came in, and in day two, that right was taken away from them. That's the situation that was being dealt with there. So it's nothing to do with whether there has to be a remedy, or indeed what the remedy has to be. And finally, my learned friend's case seems to be, this perhaps echoes something Lord Reid said, that our case on enrichment amounts to a change of position defence and is therefore contrary to Lady and Kidd. But you've had our submissions. We say there is a fundamental difference between determining the enrichment based on the obligation and a subsequent change of position, which is causally connected to the payment, but isn't connected perhaps so closely and so legally. So we say it's not that. Can I then turn to standstill provision and to reply to what my learned friend said about youths, you remember? We deal with this in our second written case, paragraphs 2 to 25. And the crucial issue here is to identify the restriction. And we say it is, as the Court of Appeal held, excluding the non-UK resident companies from the exemption provided by Section 208. I mean, it's obviously also combined with the general tax charge on dividends, but that's just the sort of flip side of the exemption. And you find that at EF 762, paragraph 84. Right at the end of that paragraph. And we say this is consistent with the way in which the CJEU characterised the restriction in the case of A. And that, you find that it's Authorities Bundle 2, tab 22, it's EF 3930. 3930 at paragraph 51 and paragraph 52. Now, you may recall what happened in this case was just simplifying matters. There was an exemption for dividends for Swedish situations, but there was no exemption for foreign situations, certain foreign situations. However, and that was the position in 1993 at the time of the standstill. However, after that, for a year, the Swedish dividends were taken. The exemption was abolished, I think, for the Swedish dividends, and then it was reinstated. And so the question was, did the restriction continue continuously from 31st December 1993? And the only way that the European Court really could come to the conclusion that it did, which is what they did, conclusion they did come to, is by defining the restriction at that level of generality, that way. They defined the restriction, as you can see in paragraph 51 and paragraph 52, as an exclusion from the exemption. So throughout the period, the non-Swedish situation was excluded from the exemption, despite the fact that one might have argued that for a year or so, there wasn't any restriction at all, in a sense, because Swedish and non-Swedish were treated in the same way. So we would say on that basis, that restriction has continued continuously since 31st December 1993 and continued after the introduction of the youth system. And we say it's not necessary, therefore, to consider the jurisprudence which is referred to in A, on national measures which were a restriction on movements of capital and were introduced after 31st December 1993. As we say, the restrictive measures in this case were Section 208, the terms of Section 208, which limits the exemption to UK companies, combined with the provisions charging, the basic provision charging a dividend to tax. So there's a tax charge unless you're within the exemption. My learned friend's approach, and Mr. Williamson's approach, is to look at, in essence, at the extent or severity of the restriction in practice. And he says if that's become greater, as he says it has when the youth system was introduced, then there's a new restriction. And that wasn't the approach of the European Court in A. Quite obviously, because when the exemption was abolished for the year, there's no doubt that the restriction became much less severe. In fact, it completely disappeared, you might say, for that year. But that didn't trouble the European Court in A. They weren't concerned with how great the restriction was. They were concerned conceptually with what the restriction, whether there was the same restriction. If my learned friend was right, it would seem to follow that every time there was a change in the rate of tax, corporation tax, then there would be a change in the restriction, because it would become more severe to be not to be exempt rather than being exempt. And presumably the same would have applied in Sweden in the A case. If there's any time there's a change in corporation tax or income tax, I think it was in Sweden, an increase in income tax, let's say, then there would be a change in the restriction. I understand my learned friend's case to hinge upon the fact that the second reference in this case, the second reference in FII, altered the understanding of what the restriction was. Now we say that's wrong. There was no change as to the restriction in the second reference. I just very brief. You may have followed the history of this, but what happened was we had the first reference. It came back and it said you can in principle operate an exemption system and an imputation system in parallel, an exemption system domestically and imputation system for foreign dividends, but only if two conditions are satisfied. One is that you give a credit for the tax paid in the foreign state up to the amount of UK tax. Well, we've always done that in relation to group dividends, so there was no problem with that. That's the double tax treaty. But the other was that the rates of tax in the UK must be the same on all companies. You may think that's a strange thing, a strange condition to impose, but that was one of the. I'll explain why that was. But that was the other condition. The problem was it wasn't clear from the judgment what they meant by rates of tax. There are two possibilities. One is it means the nominal rate of tax in the UK. Well, that was always the same for all companies, subject to small company relief, which is quite an unusual relief. And that was the reference my other friend made to footnote 47. In our written submissions to the European Court, we've mentioned this. But apart from that, which is irrelevant, the rates are the same. Or it could mean the effective rate of tax. Now, the effective rate of tax is computed by taking the amount of actual tax charged after reliefs and whatever, and comparing that to the profits in the accounts, effectively, the accounting profits of the company. So you're looking at how much tax they're actually paying on their accounting profits. And that will be lower, usually, than the nominal rate of tax. Considerably lower in some cases, obviously. Some cases they pay nothing if they've got group relief, for instance. So it wasn't clear from the judgment which of these they meant. And that was the argument for Mr. Justice Henderson. We both agreed that if they meant the nominal rate of tax, then we won, because it was always the same. If they meant the effective rate of tax, the taxpayer won on that point, because we all agreed that it was different. Companies paid all sorts of different effective rates of tax. Mr. Justice Henderson decided what they meant was the effective rate of tax, and that's why he held that the regime was unlawful. The Court of Appeal disagreed by majority. They thought it meant the nominal rate of tax, but they referred the question back to the European Court, and that's why we had one of the reasons why we had the second reference. And if we could just, sorry, just as a summary, the Advocate General in this reference said he thought, as a matter of construction of the judgment, that we were right, that it was the nominal rate of tax, but he didn't think the court's answer was sensible or coherent. So we won't look at that, but it was quite interesting, and he was probably right about that. But the court came to a conclusion. You can find that it's in Bundle 1B, EF 1650. And you can see, sorry, paragraph 39 on 1650, that just sets out the test that was set out in the first reference. The tax rate applied to foreign dividends is not higher than the rate applied to nationally sourced dividends, and the tax credit at least equal to the amount paid in the state of reference. It then went on to determine in paragraphs 41, 43 and following that in fact, in the judgment, it meant both the nominal rate and the effective rate. You had to test them both, apparently. And so, given that, the conclusion was that the two situations were comparable, and therefore the conclusion was in paragraph 54 that the legislation at issue in the main proceedings constituted a restriction on freedom of establishment or on capital movements. That's because it didn't comply with one of the conditions. Now, the reason for that condition is this. The complaint in this case, you may have understood, was that by exempting UK dividends, you allowed the UK group, I'm going back to my diagram B, sort of comparison, you allowed the UK group, the two companies, to retain the benefit of any reliefs which the company 2, the trading company, had been able to set against its profits to reduce tax. So if it paid tax at a nominal, an effective rate of 15%, that would continue, and it would be exempt in the top company. The problem with providing an imputation system is that with the second situation, that they don't necessarily retain the benefit of the reliefs, because the tax on the dividend is topped up essentially to the UK rate of tax. It would be charged at the UK rate, and they'd only get credit for the tax paid in the EU company in this example. So whatever benefit the EU company had got from reliefs would be lost essentially, because the dividend out of the profits would be taxed in the UK at the full UK rate. So that was the vice. But I think the thinking was, well, if the UK had the same effective rate of tax for all companies, then essentially the problem didn't arise, because they wouldn't be benefiting from any reliefs or exemption reliefs by definition. They would simply be being taxed on their gross profits essentially. So I think the court seemed to think if that was the situation in the UK, which clearly it wasn't, then the systems would be compatible. It would be compatible to have an exemption system for the UK and an imputation system for non-UK. But that wasn't the case, and therefore it wasn't compatible. So the point I'm making really is the restriction remained the same. The court had to determine a particular question in order to decide whether there was a restriction, but it was the same restriction that they were talking about in the first reference. It's only when you get on to to the next part of the judgment, which is about justification and proportionality, that you get to the concept of the foreign nominal rate being introduced. And that's paragraph 60, 61, 62 of the judgment, particular 60, 62. And they explain that in 61, that giving a credit at the nominal rate would resemble a grant of an exemption. Because the exemption assumes, that the court says, that the profits were taxed at the nominal rate in the hands of the company paying the dividends. Whatever you think of the rights and wrongs of that, that's what the court said. But there's no, we would say there's no basis for saying, which I think my learned friend says, that the restriction in this case has been identified as being denying a tax credit at the FNR. That's not the restriction that the European Court identified. The restriction is that identified up to paragraph 54. And that is the right approach. Well, first of all, it's obvious from Article 64 that you are looking at the restriction. But if you go back and look at some point at how the court dealt with the matter in A, the way the court dealt with it was to ask, is there a restriction on the movement of capital? That's paragraphs 40 to 44. And at that stage, having decided there is a restriction, it then considered the question of the standstill provision. Having done that, it went on after that to consider the questions of justification and proportionality. So it's quite clear that the European Court understood that the question asked by what is now Article 64 was a question about the restriction, not about anything that would be said later on about justification. Although in A it held the standstill applied, the reason it went on to consider justification is that it wasn't clear whether all the dividends in question were direct investments. It's only direct investments that are covered by the standstill provision. So in case there were some which weren't direct investments, they did go on to consider justification. One might say, even if my learned friend was right, that it was the denial of a tax credit at the FNR, the answer to that is that denial itself existed on 31st December 1993 and continued continuously up until the present, well, until at least after 2001. There was no FNR credit provided at any time. So then, can I then move on from, unless there's any questions on that, move on to a very short topic, which is the surrender of unlawful ACT. I don't know whether whether you're wanting to take a short break at some point.
Yes, I think our concentration on this sort of matter is probably aided by having a 5-minute break mid-morning. We may not be the only people who benefit from it. So we'll adjourn. I think we're now ready to resume. Mr. Ewart.
Thank you, my lord. As I said, I was going to turn on to the fairly short issue about the surrender of unlawful ACT. This is issue 11 from the Second Court of Appeal. And we deal with it in our second written case at paragraphs 147 to 162. And I just wonder whether you might want to turn that up, because the points are quite, as I say, quite short and are set out here. Just as a way of background, what we're dealing with here is part of the process, a very complicated and lengthy process of determining what you might describe as notional facts from the past. There were actual facts. Companies paid ACT, companies surrendered ACT to other companies in the group certain times, and the companies who received the surrender, for instance, subsequently utilised the ACT by setting it off against their mainstream corporation tax at various points. So we know those are true facts from the past. The problem that arose, of course, is there was no way of differentiating at the time, obviously, which part of the ACT that was paid was unlawful. And then the problem arose, well, if the company surrendered some ACT from a large pool that they had, how do you decide whether any or all or what part of that ACT is unlawful ACT, because of course it's only the unlawful ACT that's going to be subject to repayment, or subject to any remedy for repayment, or SEMPRA if it's set off type remedy. So you have to identify that, and then a further stage, when a company comes to utilise the ACT, it will have a mass of ACT, some of which will be lawful and some of which will be unlawful. And you have to determine what it's utilising at the time when it utilises it. And this is all a process determining facts which didn't in reality exist, but facts which we have to determine for the purposes of this litigation. It is, however, not a retrospective process. I think my learned friend was suggesting in some of his arguments on other issues, and some of his arguments that somehow, until you had actually decided all of this, it didn't really exist. The surrender didn't really exist. We would say that's fundamentally wrong. There was a surrender of unlawful ACT at the time, and there was a utilisation of it. It's simply, we have to discover, we have to work out through this litigation what it was at the time. But these are facts that need to be determined, and which existed. So there's nothing changes on the determination. It's just a normal case where you may have to determine complicated facts in a court case. But once you've determined them, those were the facts that existed at the time. Now, in Prudential, the court had to consider the situation of the utilisation of ACT and how you would then attribute it when it was utilised. And the conclusion that they came to was that it rather depended on what it was being utilised against. Because, of course, at the time of utilisation, you can see what it's being utilised against. And their approach is set out, it's Authorities Bundle 2, tab 14, EF 3554. And in particular, it's paragraph 110, which sets out the conclusion, where the court said, we're not able to reconcile the Court of Appeal's ruling with our decision on the Revenues Appeal on issue 3, which is inconsistent with the ruling in FII Court of Appeal, by which the Court of Appeal in this case was bound. As the revenue have submitted, and we have held under that section, and that issue, section 239 has the effect that lawful ACT is not set against unlawful MCT, which is a nullity. The pro rata method, which involves unlawful MCT being met in part by unlawful ACT and in part by lawful ACT, cannot therefore work. Instead, lawful ACT, which is not utilised against lawful MCT, remains available to be claimed against lawful MCT in the same or other accounting periods. The unlawful ACT, which company A paid, was not set against the unlawful MCT charge in a given accounting period, because both the unlawful ACT and the unlawful MCT charge are nullities. The principal answer is therefore that the unlawful ACT which company is paid must be treated as having been utilised first against the unlawful MCT charge. Where there is no unlawful MCT against which to set the unlawful ACT which has been paid, the residual unlawful ACT is to be treated as utilised against lawful MCT. And of course, there's a difference between those two things, whether it's set against lawful or unlawful MCT. When unlawful ACT has been set against lawful MCT, company has a claim for interest on the ACT so used, as stated in paragraph 78 above. That's the SEMPRA period. Now, all of this can work where you're dealing with utilisation against a particular amount of MCT. The problem arises when you're looking at the earlier stage, which is the surrender by the company that paid the ACT of the benefit of the ACT to one or more of the subsidiaries. And the problem is, of course, at that stage, you can't tell how the ACT is going to be utilised. And we say, therefore, it's quite a different situation from the situation of utilisation. At the point of surrender, the only sensible way, the only reasonable way that you can decide what is being surrendered is by, as has been held previously, a pro rata approach. So if there is 100 of lawful and 100 of unlawful ACT, and 50 is surrendered, then you simply take 25 of each as being surrendered. You then subsequently, in computations, when they come to the utilisation, of course, by the company that received the surrender, then you can carry out the process as set out in paragraph 110 of Prudential. But we say that at the surrender stage, that wouldn't be appropriate. And we set out our reasons at paragraph 154 to 158 of our case. And as you'll see there, we are relying on the also on the purpose behind Section 240 and the surrender provisions, which is to treat the company to which it's surrendered as stepping into the shoes of the surrendering company. So that the group is being treated as far as possible as a single entity, so that you don't lose the benefit of ACT because it's trapped in the wrong company in the group. So a pro rata approach means that subsidiary then is in the same position as the parent after the surrender in respect of ACT. And it is, as we say in paragraph 157, consistent with the limited nature of the deeming provision in Section 240. The deeming provision is that the company to which the surrender is made is deemed to have paid the ACT that had been paid by the other company. So, and unless there's any questions on that, I think that's all I need to say about that issue. And that brings me to issues 11 and 13 from the First Court of Appeal. It's a long time since we argued this. I argued this issue previously, and the arguments are very different now, I think, from what they were in 2010. Can I just point out a few differences, first of all, between management expenses and group relief? First of all, management expenses, as you will have seen, are applied automatically and carry forward insofar as they are surplus. Group relief, on the other hand, requires a claim for a particular amount of group relief by a claimant surrendering company and a claimant company. Any loss surrendered by way of group relief can only be used by the claimant company in the corresponding accounting period. And there are very strict rules about, complex rules about how you determine that accounting period. That loss cannot be carried forward by the claimant company. The loss could be carried forward by the surrendering company if it didn't surrender it, but it can't be carried forward by the claimant company. It's not, we would say, at all analogous to the group income elections discussed in the earlier litigation, DMG, etc. It does require a real choice by two companies, and in particular by the surrendering company, as to whether to surrender the losses or whether to retain them. and who to surrender them to. The point about the group income election was in the context of a Hearst case, it was absolutely a no-brainer that you would simply make the group income election. It was a pure matter of mechanics, as Lord Hoffman, I think, said, because by making the group income election, you ensured that no ACT was paid at all. But that is subject, of course, to the point in Pirelli that there may be circumstances where it actually benefited the group overall not to make the election because of the tax credits. But where there were no tax credits in the Hearst Gesellschaft cases, which was what I think Lord Hoffman was talking about in DMG. He was focusing on the German case. Then it was really a matter. It was truly a matter of mechanics. Now we need to look at Salonen, I think, because that's what the tax claimants rely on. But first, perhaps we need to understand what the problem is said to be in these cases. As a matter of historical fact, VAT paid virtually no mainstream corporation tax in the UK between 1973 and 2000, certainly 2001. I'm not sure thereafter. There were a few £100,000 of tax paid, I think, in around 1978. But apart from that, they didn't pay any. That was because, of course, they were able to set off various reliefs: double tax relief, ACT, management expenses, group relief, etc., against their profits. The problem, though, has arisen now is that it has been identified that certain amounts of tax that were charged, although not paid, that were charged, if you like, in theory, by the revenue, were unlawfully charged in the past. So although there was an unlawful charge to corporation tax, there wasn't any payment of tax, in fact, because at the time they utilised reliefs, etc. And this problem was addressed in Prudential in relation to ACT. You may recall that was one of the issues in Prudential. How do you deal with the problem that in some years they set ACT against corporation tax that in fact was unlawfully charged? And the answer that was given in Prudential was that if you looked at the provision about set-off, because the MCT charge was unlawful and therefore was in a sense a nullity, there wasn't any set-off. In fact, at the time, there was no set-off of ACT because there was nothing to set it off against. Although they thought there was a set-off and they thought there was a MCT, there wasn't one. And therefore, under the way the statutory provisions work, the ACT simply carried forward. And whatever the consequences of that would be, but it carried forward automatically to the next accounting period, next accounting period of the company. So that was how ACT was dealt with in Prudential in this situation. The problems that we have here are in relation to other things, which are management expenses and group relief losses. But both of these have it's the same issue really in both cases, in all three cases, which is the relief was set against what was thought to be a true charge to corporation tax, but we now know that it wasn't. And that is the essence of the taxpayer's complaint. And they point to Salonen, which is Authorities Bundle 2, tab 21, it's EF 3827. Can I just take you briefly first to the Advocate General Advocate General, which is at EF 3861. And what he says, particularly paragraphs 150, 151 and 152. Mr. Aronson has taken you through this. The vice is summarised in paragraph 150. And then 151, the Advocate General says, if the foreign corporation tax previously paid on the foreign dividends could no longer be credited in that subsequent year, or important to note, taken into account in some other way, there would in the final analysis be double taxation, which, as the referring tribunal states, is specifically prevented by the imputation method. Now, something that you have to remember is that Salonen was not dealing with unlawfully levied tax. It was in fact dealing with a more prosaic situation, which was under the system, actual double tax relief that was given before, losses were given, relief for losses was given before double tax relief under the relevant tax system. And so the effect of that was the losses used up the profits, and there was nothing to set the double tax relief against. And as is almost universal, I think, the system was that if you didn't use the double tax relief because there wasn't any tax, it couldn't be carried forward in any way. Because it's in principle, double tax relief, of course, is particular relief against particular tax in relation to a particular dividend. That's the point of it. Tax has been paid in the foreign country, and the dividend has been paid out of that profit, out of the profits, and the double tax relief is designed to alleviate the economic double taxation that arises when the profits are then taxed in the UK, when the dividend is taxed in the UK, let's say, or any country. So the way that the systems always work is that the dividend, the DTR can only be set against the tax on the particular dividend. And of course, different dividends will carry different amounts of DTR because different amounts of underlying tax will have been paid in respect of each particular dividend. So it's very particular to the dividend. The problem that was addressed by the European Court, by the Advocate General and the European Court was, well, because of that, you lose the benefit of the double tax relief. And that, I think, was regarded as being a breach of European law, because if you remember, one of the conditions for operating an imputation system alongside a parallel exemption system, which is what they were doing in this country, just as in the UK, it is that you should give relief for the tax paid in the foreign country. And I think what was being said is, well, if you have a system whereby the losses are set off first, then you're not giving relief for the foreign tax, and therefore you're not complying with the conditions which are necessary to have an imputation system. Now, the problem that we have is a slightly similar, analogous, but slightly different problem, which is that we have a situation where there was unlawfully levied tax, we know now, but reliefs were set against it, it seemed at the time, and the result of that is the reliefs were wasted in a sense because they were used against income that was not actually chargeable to tax. If they had known that position, they would simply have carried forward the relief or the management expenses. Certainly, I'm talking about management expenses at the moment. Different considerations apply for group relief because of the nature of it, but the management expenses would have been carried forward. Now, the question is, how does one rectify that problem in the UK? And there seem to be two possible answers in relation to group management expenses. One is the answer which the Revenue have proposed, which is that you construe Section 75 in such a way as to allow the management expenses to be carried forward in relation to income that would be unlawfully charged. So you don't lose any of the management expenses. The alternative, I think, proposed by the taxpayer, the test claimants, is that you carry forward the double tax relief, essentially, the notional EU credit at the FNR to later years. The problem that we see with that is, first of all, it is completely contrary to the structure of the UK tax system, which doesn't recognise carry forward of double tax relief in any way. The advantage of carrying forward the management expenses is that that is a recognised way of dealing with management expenses. There are provisions about carrying them forward. The other problem seems to be that it doesn't seem to be as generous to the taxpayers, because if they're carrying forward the double tax relief, one presumes, because it is double tax relief, they're only going to be setting it against foreign dividend income. Whereas if you carry forward the management expenses, you can of course set them against your total profits, all of your profit, any of your profit. There's no restriction. So it seems a much better solution to carry forward the management expenses. But we don't really understand that there's any, in the end, any difference in the analysis, whether it's one or the other. Apart from, as I say, the fact that it seems more restrictive with the DTR. Because in both cases, a relief is being carried forward. And in both cases, we would say that the taxpayer's claim, which is that they're entitled to some kind of restitution in the year in which the management expenses were originally set against income, in either case, that claim we would submit is hopeless, because in that year, there was no enrichment of the revenue. There was no enrichment at the expense of the taxpayer. There was no transfer of value at all. Nothing transferred from the taxpayers to the revenue. All that happened was that the reliefs carried forward. A relief carried forward one way or another. So it's difficult to see really what difference it makes which analysis you adopt as regards the claims in unjust enrichment in any event. It may have some difference in other ways in feeding into the tax system. We say our approach is analogous to the approach in Prudential, with this one difference, which my learned friend quite rightly points out. I think we made this clear in our case as well. In Prudential, the ACT is a much more straightforward case, because the ACT is set against the corporation tax. And so if the corporation tax charge is unlawful, you can see quite easily how the ACT was not set off. Management expenses, on the other hand, are set against profits. So they're part of the computation of the profits, and then the tax charge is applied to the profits. But of course, you can get to the same effect by deciding how much of the profits represent the unlawful tax, and then essentially carrying forward that amount of management expenses. It's not a very difficult process, and that would produce the same effect, that you would be carrying forward the management expenses that would otherwise have been set against the unlawful charge, or rather, they'd be set against the income that was subject to the unlawful charge. So we say that that approach goes very much with the grain of the legislation and provides an answer. The problem in Salonen may well have been because this wasn't an unlawful, we weren't talking about an unlawful charge at that stage, it may just not have been possible under their system to have carried forward the losses in some way. It's unclear from the judgment. In any event, the questions were being asked on the basis that the losses could not be carried forward. And so the court said, well, if that's the case, then you'd have to be able to carry forward the double tax relief. So we say, as regards management expenses, whichever solution you adopt, there isn't any room for there being a claim in relation to the period in which the management expenses were originally purported to be used, simply because there is no enrichment and there's no unlawful charge. So there's no question of any San Giorgio remedy being required. No tax has been charged at all, in fact. It's hypothesized. My learned friend says that the use of the reliefs is equivalent to a debt being forgiven. But I'm afraid I don't really understand the analogy. When a debt's forgiven, there is an immediate enrichment at the expense of the creditor. There is a transfer of value. Before it's forgiven, you owe them £100, and after it, you owe them nothing. That's quite a clear case of an enrichment. Whether it's unlawful, whether it's unjust or not, it's a question, but that would be an enrichment. But there's nothing similar in this case. The position, so the management expenses will carry forward and the consequences will flow from whatever flows from that. But I think importantly, the claim here has been always that they're entitled to a claim in relation to the year in which the reliefs were, in a sense, lost. Well, they were utilised, but wrongly. And we say there isn't a claim in respect of that. Group relief is different. It's an important feature of that the claimant company cannot carry forward the loss which it's received. So we're not in exactly the same position as in Salonen. We're not in a position where the unlawful charge has caused reliefs that would otherwise be carried forward in the claimant company, in the claimant company's hands to be lost. Where there is a problem is at an earlier stage, which is that the surrendering company decided to surrender those losses in the mistaken belief that the claimant company had chargeable profits. So as regards the claimant company, we would submit that there cannot be any requirement to carry anything forward because the loss that we're looking at couldn't be carried forward itself. The question is, what remedy would the surrendering company have? And that might depend on proof as to what the surrendering company would otherwise have done. And this is why we argued below, and the Court of Appeal accepted, that this would be a situation which would sound in damages rather than unjust enrichment. The complaint would be essentially there was a breach of EU law, and as a result of that, we suffered a loss because we would have done something different if there hadn't been this breach of EU law. But we would submit that, again, in the original year, there wouldn't be a claim in unjust enrichment, and we would suggest that there wouldn't be, we would submit there wouldn't be a claim at any point in relation to this in unjust enrichment. It would be purely in the terms of the European Court. Perhaps we can just to turn that up. It's in volume 1B. It's the first reference judgment, and it's page EF 1570. And it's paragraph 207. Where they draw a distinction between waivers or reliefs, where this is in the middle, letter D, such waivers or reliefs or increases in the amount of dividends are the result of decisions taken by those companies and do not constitute on their part an inevitable consequence of the refusal by the UK to grant these shareholders the same treatment as that afforded the shareholders receiving a dividend distribution which has its origins in nationally sourced dividends. So cases where there was unlawfully tax charged and amounts which relate to that would be recovered under the San Giorgio principle, but not matters indirect losses caused by breaches of EU law. So it's, yes, paragraph 205. Where member states have levied charges in breach of the rules of community law, individuals are entitled to reimbursement not only of the tax levied, but also amounts paid to that state or retained by it, which relate directly to that tax. And we say that is a reference to things like, for instance, if the taxpayer originally paid his tax late and paid interest on the tax, and it turned out to have been unlawfully charged, then they would obviously be able to recover the interest or any penalties or anything like that that they had to pay. But this is not an amount paid or retained which relates directly to the tax in any way. I'm assuming, for the sake of argument, that they could show that there was some loss. Obviously, that'd be a matter they'd have to prove. There may well be cases, of course, where they could never use the losses. In fact, because the surrendering company never made profits thereafter. In which case, it would be hard to see there was any loss at all because they couldn't have done anything else with the losses. But that would be a matter of proof if in a damages action. So as I say, the arguments are somewhat a little bit different now from those before the Court of Appeal. In the Court of Appeal, it was all dealt with really on quite a high level of generality, you may note, and it was based on the propositions that the taxpayer was putting forward that they had a claim in unjust enrichment and San Giorgio, particularly in respect of the original period in which the reliefs were lost, they said. Of course, we didn't then have the analysis in Salonen, etc., that we have now, which demonstrates that in some cases the reliefs weren't in fact lost at all in any sense. That, unless there's any questions on that, issues 11 and 13, that leaves me to deal with what is called issue 26A, which is the final issue, which relates to the SEMPRA period. I was proposing to deal with this in the opposite order from my learned friend, Mr. Bremner, as I did in opening, which is to deal first with the estoppel abuse arguments and then to deal with the substantive point. It's clear that my learned friend has to rely very heavily, if not entirely, on the order of Mr. Justice Henderson, following High Court 1, as founding a cause of action estoppel. He has to do that because anything relevant that was decided in the second judgment is under appeal. You cannot found an estoppel, obviously. So could we then look first at Mr. Justice Henderson's order following the first trial, which is EF 947 in the core volumes. And the paragraphs which he relies on are particularly paragraphs 11 and 13 in the declarations, which is on 947. And what he has to say is that this is a determination, a final determination, that there is a cause of action in English law of unjust enrichment in relation to the SEMPRA period, put in shorthand. And we would submit, simply by reading this, you can see that it doesn't determine that at all. What it determines is that there is a claim, and paragraph 11 essentially is dealing with the European claim and makes it clear that there is a claim for compensation or damages, which is the European terminology, based on San Giorgio, and that extends to the repayment of unlawfully levied tax and all claims for losses which are a direct consequence of the unlawful levy. That's just tracking, in a sense, the European Court decision. And then paragraph 13, referring to the claims for unlawfully levied ACT, they fall within a state-based restitutionary claim, which the state continued to be operative at the time the payments were made. But as I submitted in opening, this isn't a determination of the claims for the SEMPRA period. My learned friend has to get it to do that. He has to construe it, he says, in the light of the judgment. But we would say that's not a legitimate way of construing a court order. You might ask the question, you can test the question really, is if the revenue had sought to appeal this order on the grounds that SEMPRA was wrong, relying on the points essentially prudential, would they have been able to do so? And I would submit no, because the answer that would come back is this has nothing to do with claims for unlawfully levied ACT. They are clearly there. They are straightforward claims in unjust enrichment. ACT has been unlawfully levied. You're entitled to have it back. I lost everyone for a moment there. I don't know if that's if you.
No, I don't think
right.
that's anything.
No, okay, Good. So that was my submission on that, and that's made, I think, absolutely clear when you then look at the order following the second trial, which is it's EF 970. And it's Declaration 23. Which relates, as you see from the top, to issues 25 and 26A. And if you turn on to page 981, you will see what issue 25 and 26A were. 25 was, A, are the claimants entitled to restitution of the principal sum of unlawfully paid tax, the time value of the unlawfully paid tax if paid too early, and 3, interest on both those sums. So now the Little Roman 2 is a separate period, and Little Roman 3 is secondary, what we call the secondary periods. And the rate, the type of interest that is available to the claimant crucially depends upon the correct categorization of the claim. This was a point, sorry, I was making to Lord Hodge, which was, this is not a question as to whether the interest is simple or compound in a vacuum as a kind of standalone question. It depends upon the answer to the question, were the claimants entitled in restitution or in unjust enrichment, as you might call it, in relation to these periods? Because the test claimant's argument was, we would normally be entitled to interest under Section 35A. That's simple interest. That would be the normal situation. However, we in fact have a claim in unjust enrichment for this period, a principal claim in unjust enrichment from the date the tax was unlawfully paid to the date of judgment. And therefore, we're entitled, and it's that which gives us an entitlement to compound interest for that period. Nothing else would. So the reason that we're entitled to it was that. And that's why this was the issue. The issue was, are they entitled to restitution? Restitution in the technical, the legal sense, in unjust enrichment for those periods. And of course, Mr. Justice Henderson had already decided at this stage, before we got to this trial in Prudential, that they did have a claim in unjust enrichment for that period. That was the very first time this issue was ventilated, if you like, in court. The first stage in Prudential, the first instance. And after looking at Sempra in some detail, he concluded that they did have a claim in unjust enrichment for the period. So 25 and 26 are linked. I think it must be the answer. We've continued to label it 26A throughout, but I think in fact what was being decided was certainly 25A3, and 25A2 was also an issue, or under appeal, let me say. So it seems impossible to argue that there had been a determination of a cause of action where it was agreed at the second stage that one of the issues would be whether the claimants were entitled to restitution of the time value of the unlawfully paid tax. And Mr. Justice Henderson seemed to understand that, because in his declarations, he actually made a declaration, which is 23A2, about the entitlement to restitution for the prematurely paid ACT. So it isn't simply a matter of quantification. Of course, all of these arguments, as many arguments do, lead to quantification. But it isn't quantification in the sense of trying to work out the amount of damages someone's entitled to for loss of earnings or something like that. It's quantification in the sense that it requires, at the stage before that, a decision in principle as to the nature of the remedy that the taxpayer, that the test claimants have. As regards Henderson and Henderson, I'm sorry, on cause of action estoppel, I would repeat what we said in opening. In particular, I think the point which arises from Virgin, which is even in Virgin, where there was a cause of action estoppel, you might have thought, because the Court of Appeal had finally determined the matter in the very proceedings, that wouldn't bind the court on a true quantification issue, because in between the determination of the Court of Appeal and the quantification, another court, which was superior, it seems, had retrospectively determined the issue the other way. And that's what happened in Virgin, essentially. So if we need to fall back on that argument, we would, but we don't think we do, because we don't think we get that far, because there never was a cause of action estoppel in the first place. As regards Henderson and Henderson abuse, this applies in situations where a point wasn't taken, but should have been taken in earlier proceedings or in an earlier stage of the same proceedings. Again, we would say it's impossible to argue that's the case, where it was agreed as an issue in the second stage and enshrined in a declaration made by the judge. We say, therefore, prejudice is irrelevant, in fact, because we don't even get onto that question. But we would maintain our position that we don't accept the allegations of prejudice that the taxpayer makes. In particular, we don't agree with the idea that they would simply have abandoned their claims for compound interest for the secondary period at first instance in this case, if they had been advised that SEMPRA could be overruled at some stage if the case reached the Supreme Court. And the other difficulty with this argument is the fact that SEMPRA could be overruled is simply a legal fact. It's not something that is within the knowledge of any one party. So it's something that any litigant would be should be aware of. And if they're not aware of it, then that's simply because they haven't been advised that that's a possibility. But of course, it's always a possibility that that a matter something will be overruled. It doesn't happen very often, it's true, but it's certainly always a possibility. And so, yeah, happening more often.
Happen more often than these proceedings than hopefully does.
Yes, I think that's a fair point.
But it's because these proceedings have been at the cutting edge, really, from the outset. I mean, the cases that we've overruled will themselves taken in these or related proceedings.
Yes, and one of the problems, I'm sorry, one of the problems in these kind of cases is you get a case like Clement Benson. The main point, everyone concentrates on the main point, and you find that the subsidiary points get sort of swept along with it often.
Yeah.
They don't get perhaps the focus that they needed in some cases. And the same in DMG.
I mean, the thunderbolts that come from, if not Olympus, but from the Kirchberg, sort of throw a spanner in the works from time to time. I mean, for example, SEMPRA was based on a certain view that compound interest was required by EU law. Later decisions of the ECJ indicated that wasn't the case. Someone has to, someone has to respond to that kind of clarification.
Yes, But certainly what you say is right about these proceedings, both as regards European law, but also as regards domestic law, yeah, and the law of remedies. There have been a lot of issues that have had to be decided in these proceedings. I guess this is the successor to the unlawful swaps. Although even that litigation wasn't as great as lengthy as this.
No, it's difficult to think of any litigation that's given rise to so many important and novel questions of law.
Yes. And we're just moving on to another of these, which is the substantive argument, Mr. Bremner's argument, as to what the true position in law is. Now, we would say that this analysis, which he gave you yesterday involving Section 35A, is fundamentally flawed. Can we go back slowly to the beginning? He starts from the proposition that an unlawful amount of ACT was paid. And he says, quite correctly, at that stage, there arose an immediate claim in unjust enrichment to recover the unlawfully levied tax or mistakenly paid tax. And if the claim had been brought then, or sometime soon after the payment, they would have recovered the tax had they succeeded, and would have had to be repaid the tax with Section 35A interest, presumably. However, the company subsequently became liable to a lawful charge to corporation tax. And that was discharged by setting off the ACT. And that amounted, we would say quite clearly, to a repayment, essentially, of the unlawful ACT. As Mr. Bremner candidly admitted, there were also situations under the FID regime where the ACT was literally repaid in cash by the revenue to the taxpayer. The way the FID regime worked was you paid the ACT when the first time for corporation tax to be paid came for the company. If they couldn't set the ACT against the MCT under the normal rules, it was automatically repaid to them at that stage. So that was an even clearer, absolutely clear case of the being repaid. So you're then in a situation where you've paid an unlawful tax or by mistake, but the money's been repaid to you. The amount of the enrichment has been repaid to you. So you're in exactly the same situation as anyone who's had their restitution repaid. And of course, that kind of situation led to the problem which was addressed in Mettelgesellschaft. Because the problem was, under English law rules at that time, in the 1990s certainly, you couldn't bring any kind of claim in relation to something where the debt or the damages had been paid, because you didn't have any cause of anything to sue for anymore. So you couldn't recover interest, which you would have been able to recover, at least under Section 35A, if you had managed to bring your claim just before they repaid you. So it's a slightly anomalous situation. So the ECJ said in Mettelgesellschaft that this English law rule couldn't cause it to have no remedy in relation to the set-off ACT, and therefore that there was a claim, a San Giorgio claim, not for the ACT, but for the time value. So there was a claim, a principal claim, the principal sum being the time value of the ACT. Now, so as I say, it wasn't a claim in any respect for the original ACT that had been paid, because that had been repaid. Could it be brought in mistake, this claim? That was the question. In Sempra, they decided it could, but Prudential held that that couldn't happen because there was no transfer of value in not repaying the amount owed after the unlawful ACT was paid. So there was a transfer of value of the unlawful ACT, but that had been negated by the repayment. There wasn't a transfer of value in simply not repaying it, essentially, thereafter. So there wasn't any remedy in unjust enrichment. How could Section 35A apply to that situation? Well, we need to then take up authorities 1, that's tab 6. EF 3230. Now, what my learned friend has attempted to do was to apply Section 35A to the original sum of ACT that was paid by mistake, because he couldn't apply it to the time value claim because we know that there is no claim in unjust enrichment for that. So he applied it to the original claim. But if you just read Section 35A, you can see that it simply doesn't apply, because there has to be proceedings before the High Court for the recovery of a debt. Now, the amount that he was talking about, the amount originally paid, there are no proceedings for the recovery of that amount as a debt. Debt is taken to include restitutionary claims. And they couldn't bring a claim, and they haven't sought to bring a claim to recover the ACT that was paid but was then set off. And it goes on to say they may be included, which obviously also emphasises the fact that you have to have a claim. There has to be something else apart from the interest, that is, the debt or damages that you're recovering. They may be included in any sum for which judgment is given, simple interest at such rate, etc. So we would say there's no possible way in which Section 35A could apply parasitic on, in some way, the original payment of ACT. Now, I think my learned friend has to say that. He has to say that in order to continue to have a claim in relation to periods going back to 1973 in relation to time value. Because the only way that you can have such a claim is if you are founding it on relief for the consequences of a mistake within Section 32(1)(c). And so he has to link it to a mistaken payment, which is what he attempts to do, but we would say that's just impossible. The only possibility would be to somehow read Section 35A as some kind of freestanding right to claim interest in respect of the Sempra period. But and I've made submissions about that as to why we think that's not possible, because of the various features of Section 35A. It goes against the grain of a number of the features, but also because I think, as perhaps Lord Sales was suggesting, what this is in fact something which empowers the court, when it gives judgment, to grant interest at its discretion. Now, I quite understand that in this case, the parties have agreed rates of interest that would apply under Section 35A. And I also understand that there is a practice. There is a standard rate of interest that is generally applied on Section 35A, which I think is normally at the moment now 2% above base. It used to be 1% above base, but that changed, I think, at the time of the financial crisis, because interest rates became so low, I think, that it was thought that 1% above base was not very much. So, but I don't know what that was the thinking. But anyway, it is now at present 2% above base. That is the general practice. But of course, it is still a matter of the discretion of the court. And as a matter of principle, the nature of this provision is one which the court decides at the time of judgment what interest to grant. So it's not a very suitable vehicle for giving a right, a San Giorgio type right, to obtain interest for the period of prematurity. But even if it does, even if you can achieve that, we say it then is simply a statutory right to recover, you might call compensation, by way of interest. It's not a claim in mistake. And therefore, it would have the normal 6-year limitation period as provided for, I think, in Section 9 of the Limitation Act in relation to claims under statute. So that would give the taxpayers a remedy, but it would be limited by the normal limitation period. I was going to go on. Sorry, Lord Sales, yes.
I just wanted to check, presumably, because these proceedings go back so far in time, there will be some cases where there was an extant restitutionary debt at the time the proceedings were started, to which Section 35A is capable of applying, and so other cases where the restitutionary debt had been cancelled out by set-off before the proceedings began. So is this right, that we're going to have to deal in our judgment with both those sorts of cases?
There are both sorts of case, my lord. There are cases where ACT was paid and was never utilised. There are also cases where it was paid and utilised against unlawful MCT, which are also treated as cases where it's outstanding for the purposes of this litigation, because it's a nullity, if you like. So there are such cases. And in those cases, they're entitled to the ACT back, the principal sum, the amount they paid, plus interest under Section 35A. But the cases that we're talking about at the moment under this issue are the cases where there was set off before the proceedings began, or repayment.
Is that right, that this issue is purely in relation to proceedings where there was unlawful ACT, but then set off before the proceedings began?
Yes, because those are the cases where Prudential says that they didn't have a claim in unjust enrichment. They would have had a claim for the straightforward. Yeah, that's right. Yeah,
right.
But there's quite a lot of those. There are a lot of those. That might be a convenient moment.
Yes, certainly. We'll adjourn now and sit again at 2 o'clock. Thank you.